Yes.
And what is the law firm that you're with?
Raub and Sanders.
Okay, great, thank you. And first, I mean, were you surprised by what went on in there today? I mean, the judge basically said that, oh, well, there's no case.
Well, we always felt that there was no case. And obviously, we felt strongly that he was taken involuntarily, contrary to the statutory scheme. And obviously, there was one more aspect, which was that the initial petition was meaningless. So I think the judge and the overall scope of everything realized the futility of going to a hearing. This man was taken from his home without lawful authority. He's been incarcerated, my words, and held unwillingly against his will for almost a week. And it was time to let him go.
Have you spoken to Brandon?
No, not yet. I hope to call him on the way back, obviously.
Tony, could you tell us a little bit about where in the process the document that so upset the judge was issued, when that happened, and what the context is to the rest of the proceeding?
Sure. The first document would have been an emergency order to take custody. The second document would have been a petition to move the matter forward. That's where the judge found there was a petition with a signature and no allegations, none. And in fact, the petition is designed for all sorts of boxes that can be checked. Now, to try to give you some semblance of the problem, none were checked, as the judge indicated.
So this was before TDO?
Yes.
Can you explain also?
And then the TDO, temporary detention order, as we argued, was issued without lawful authority either.
Can you shed some light on sort of like the catalyst for all of this? I mean, I think we know the FBI got some kind of phone call, and then how did it end up that there was an emergency order to begin with?
Well, obviously the catalyst for everything is the fact that Brandon is at home, relaxing, gets a knock. There's an FBI agent and a Secret Service agent who announced themselves and indicated that they're there because of their concern for him, based on postings. Now, I don't know how many times the Secret Service is going up and down neighborhoods, knocking on doors, to tend to the well-being of citizens. So obviously, this was his postings. And he was saying things such as, let's overthrow the government. Well, remember, Thomas Jefferson said the tree of liberty should be expunged with the blood of patriots and tyrants. If Thomas Jefferson were living today in Virginia, he'd probably be committed in a mental institution. This is ridiculous. There are statutory schemes. There is a need to take certain people against their will for treatment. There's a statutory scheme that the legislature has laid out balancing everything. And you can't take liberty away unless you follow that statutory scheme. We're talking about freedom of citizens. I know people are concerned in this day and age. Look what happened in Aurora, Colorado. Look what happened in Wisconsin. Well, the answer is the legislature has tried to balance those concerns and laid out a specific statute to be followed. And if it's not followed, end of inquiry. You have to let our citizens live free unless they're taking in properly, and obviously Brandon Raub was not. So the answer to your question is his Facebook postings.
Were the catalyst. It
were the
wasn't
catalyst.
Someone calling them, and there wasn't an anonymous phone call or anything like that to authorities that.
Well, I don't know.
This? Okay.
I don't know. They claim there was.
Tony, what was the nature? Was there any documentation at all or conclusion on the part of the examiners of what condition he had that warranted involuntary?
Well, it's a two-step process.
Right.
And the first process is a finding of mental illness. But that is far from the end. They found that he had some type of psychosis. They did not say what it was. But then, notwithstanding that, the next step has to be that even if you find a psychosis, you have to find, by clear and convincing evidence, a substantial, that he poses a substantial risk, in this case to others. And by calling for the government to be overthrown is not a risk to any individual person. And that's when I got into the difference between a threat, which is protected by the First Amendment, and a true threat, which is not. A true threat has to put a reasonable person in fear that he will be injured, not that a revolution may come to this country.
What about that mental illness? What was that mental illness that they were?
Psychosis. Beyond that, your guess is as good as mine.
Tony, there's been a huge amount of attention paid to Virginia's involuntary commitment procedure since ago. The Cell Commission, bunch of study, rewriting the statutes. What does this case know about the susceptibility of that whole framework to the actual people filling out filling in the blanks?
Maybe I, in my profession, have to take COE, continuing legal education. Better education on the exact statutory scheme, because after Cho, our General Assembly specifically in detail strengthened, determined the rights of people and balancing against the need for treatment. They spelled it out explicitly. I mean, it couldn't be more black and white, and yet it's not being followed.
Do you think we're going to see more cases like this in the future?
I hope not. I mean, this man, fought for almost 2 years, risking his life to come back to this country and be able to say what he wants to say.
When will Brandon?
Lord, who else's voice should be more protected?
When will Brandon be coming back? Do you know?
Forthwith.
Legal term.
Yeah, tonight.
We're getting his mother here. We have a court order.
And so she can leave right now and go get him.
She's going to go get him.
That's great. Thank you.
Like any mother would.
Great job.
Take care. Good seeing you. Nice
Thank
seeing
you so much. Nice to meet you.
Anything else?
I got one more question for you, Mr. Troy. You explained to the judge that that the FBI missed one step, so to speak, and you got the judge.
No, not the FBI.
The Chesterfield Police, maybe?
No, the CRC, the Community Service Board, and their intake process of taking a person involuntarily into commitment.
Okay, because your point was they were only allowed to hold him within 6 hours.
4 hours only, 2 more if requested.
Right, okay.
And they can't hold him beyond that.
Right, which obviously they did, and that's why he struck, for the most part.
Right.
Is he going to be seeking a civil suit in response to this whole ordeal?
I have no idea. That's another conversation for another day.
Okay.
Thank you.
Thank you.
Thanks for championing liberty.
Thank you.